The year was 1891. Spain ruled the islands through the iron fist of Governor-General Valeriano Weyler. Ilustrados studying in Spain were in the midst of a second propaganda campaign. They published the newspaper La Solidaridad and wrote passionately about unity and self-determination. In Belgium, José Rizal published his second novel entitled El Filibusterismo. At home, a revolution was afoot, and a nation was about to be born. On April 8, 1891, Spanish lawyers based in Manila and those mentioned in the Spanish Royal Decree of 1891 were summoned to a meeting at the Real Audiencia in Intramuros. The purpose of the meeting, presided by Magistrado Eduardo de Ortuña, was the establishment of the Colegio de Abogados de Filipinas and the election of its first executive board. The Governor-General appointed José Juan Icaza as Decano of the Colegio. And in that summer of discontent, one of the oldest associations of lawyers in Asia was established. The Colegio adopted its estatutos to govern the organization. It was granted juridical personality with powers to police its own ranks. A few years later, the Philippine Revolution broke out in 1896. Many members of the Colegio joined the fight for independence. Apolinario Mabini, a Colegio member, was regarded as the brains of the Philippine Revolution. Felipe Calderon, also a member of the Colegio, drafted a Malolos Constitution. As the Spanish Empire fell and American rule was established, American lawyers crossed the Pacific to practice law in the Philippine Islands. At the turn of the century, they organized themselves into an association of lawyers with ties to the American Bar Association. On June 24, 1904, under the inspiration of Chief Justice Cayetano Arellano, the Colegio de Abogados de Filipinas and the Association of American Lawyers in the Philippines merged, giving birth to the Philippine Bar Association. American lawyer Thomas L. Hardigan was elected as its first president. Among the members of the PBA at that time were Felipe Calderon, Gregorio Araneta, Rafael Del Pan, and Juan Sumulo. In 1924, Jose Abad Santos was elected president of the PBA. He was later appointed Secretary of Justice and Chief Justice of the Supreme Court. In 1942, while serving as the nation's caretaker during the occupation, he was captured and executed for refusing to collaborate with the Japanese invaders. On February 24, 1945, as Manila was bombarded by American forces during the War of Liberation, the PBA building in Intramuros was turned into ruins. With our nation rising from the ashes of the horrible war, the PBA helped in the task of rebuilding our legal institutions. On August 1, 1946, the canons of judicial ethics were adopted upon the proposal of the PBA. The decade following our independence saw a fervent tide of nationalism sweeping our land. It was a time for a rebirth. On March 27, 1958, prominent Filipino lawyers incorporated the Philippine Bar Association as the direct successor of the Colegio de Abogados de Filipinas. In recognition of the importance of the rule of law in our national life, in 1959, President Carlos P. Garcia proclaimed September 19 of each year as Law Day throughout our country. To this day, the PBA commemorates Law Day each year as a reminder that we are a nation ruled by law and not by men. It also marks the annual transition in the association's leadership. In 1966, the PBA returned to Intramuros and built itself a new home. But the great earthquake that shook the capital in 1968 reduced the PBA building to rubble.
I joined the Philippine Bar Association in 1968 at the prodigy of my friends in the law practice, including Ike Bello, Gonzalo Gonzalez, and Dick Romulo. I also thought that it would be nice to join an association and be associated with the legal luminaries of the time, including Abad Santos, Recto, Delgado, and Tadjana, whose names are now legendary.
The 1970s saw a nation torn with strife and the rise of a ruthless dictator. The PBA was among those who condemned the imposition of martial law and the brutality that followed. In the dark years of the dictatorship, the PBA stood watch, investigated human rights violations, and against tremendous odds won cases for those illegally detained. In 1983, the PBA joined the nation in mourning the assassination of Senator Ninoy Aquino. As our democratic institutions were gradually restored following the 1986 People Power Revolution, the PBA also undertook its own efforts at restoration. It found its new home in Makati City, the new financial capital of our country.
In 1968, when the great earthquake destroyed our building in Intramuros, it became the leaning tower of Intramuros. And after a while, we filed cases against the contractor and the architect. And then the land was sold by our president then at the time, and the proceeds of which was used to buy our present office condominium.
And in keeping with the times, the PBA elected its first lady president.
My romance with the Philippine Bar Association started when Mr. Federico Agrava, as the husband of Justice Corazon Juliano Agrava, invited us to be a member of the organized Philippine Bar. Pasita de los Reyes Phillips, who has been the treasurer for all these years, resigned as treasurer, and the board appointed me as treasurer. I accepted because for me, It's a big honor to be treasured of such a very good organization. It took 19 years, or 17 or 18 years, when the Courtney and the lovable members of the board decided that maybe they should, after all these years of service, to reward me with something. And that's when they elected me as president of the Philippine Bar. At that, the first woman president of the Philippine Bar.
The history of the PBA is fundamentally intertwined with our nation's history. And as our history continues to be written, the PBA remains in constant watch, speaking truth to power and challenging the excesses of the rulers of the day, both in the real world or in cyberspace. We are the PBA, heirs to a glorious past, kindred in noble purpose, to blaze the future's path. Through time we have stood constant, faithful to our oath, champions of the oppressed, and guardians of the truth. We are the PBA. We stand for the rule of law. The year was 1891. Spain ruled the islands through the iron fist of Governor-General Valeriano Weyler. Ilustrados studying in Spain were in the midst of a second propaganda campaign. They published the newspaper La Solidaridad and wrote passionately about unity and self-determination. In Belgium, José Rizal published his second novel entitled El Filibusterismo. At home, a revolution was afoot, and a nation was about to be born. On April 8, 1891, Spanish lawyers based in Manila and those mentioned in the Spanish Royal Decree of 1891 were summoned to a meeting at the Real Audiencia in Intramuros. The purpose of the meeting, presided by Magistrado Eduardo de Ortuña, was the establishment of the Colegio de Abogados de Filipinas and the election of its first executive board. The Governor General appointed Jose Juan Icaza as decano of the Colegio. And in that summer of discontent, one of the oldest associations of lawyers in Asia was established. The Colegio adopted its estatutos to govern the organization. It was granted juridical personality with powers to police its own ranks. A few years later, the Philippine Revolution broke out in 1896. Many members of the Colegio joined the fight for independence. Apolinario Mabini, a Colegio member, was regarded as the brains of the Philippine Revolution. Felipe Calderon, also a member of the Colegio, drafted a Malolos Constitution. As the Spanish Empire fell and American rule was established, American lawyers crossed the Pacific to practice law in the Philippine Islands. At the turn of the century, they organized themselves into an association of lawyers with ties to the American Bar Association. On June 24, 1904, under the inspiration of Chief Justice Cayetano Arellano, the Colegio de Abogados de Filipinas and the Association of American Lawyers in the Philippines merged, giving birth to the Philippine Bar Association. American lawyer Thomas L. Hardigan was elected as its first president. Among the members of the PBA at that time were Felipe Calderon, Gregorio Araneta, Rafael Del Pan, and Juan Sumulo. In 1924, Jose Abad Santos was elected president of the PBA. He was later appointed Secretary of Justice and Chief Justice of the Supreme Court. In 1942, while serving as the nation's caretaker during the occupation, he was captured and executed for refusing to collaborate with the Japanese invaders. On February 24, 1945, as Manila was bombarded by American forces during the War of Liberation, the PBA building in Intramuros was turned into ruins. With our nation rising from the ashes of the horrible war, the PBA helped in the task of rebuilding our legal institutions. On August 1, 1946, the canons of judicial ethics were adopted upon the proposal of the PBA. The decade following our independence saw a fervent tide of nationalism sweeping our land. It was a time for a rebirth. On March 27, 1958, prominent Filipino lawyers incorporated the Philippine Bar Association as the direct successor of the Colegio de Abogados de Filipinas. In recognition of the importance of the rule of law in our national life, in 1959, President Carlos P. Garcia proclaimed September 19 of each year as Law Day throughout our country. To this day, the PBA commemorates Law Day each year as a reminder that we are a nation ruled by law and not by men. It also marks the annual transition in the association's leadership. In 1966, the PBA returned to Intramuros and built itself a new home. But the great earthquake that shook the capital in 1968 reduced the PBA building to rubble.
I joined the Philippine Bar Association in 1968 at the product of my friends in the law practice, including Ike Bello, Gonzalo Gonzalez, and Dick Romulo. I also thought that it would be nice to join an association and be associated with the legal luminaries of the time, including Abad Santos, Recto, Delgado, and Tayana, whose names are now legendary.
The 1970s saw a nation torn with strife and the rise of a ruthless dictator. The PBA was among those who condemned the imposition of martial law and the brutality that followed. In the dark years of the dictatorship, the PBA stood watch, investigated human rights violations, and against tremendous odds won cases for those illegally detained. In 1983, the PBA joined the nation in mourning the assassination of Senator Ninoy Aquino. As our democratic institutions were gradually restored following the 1986 People Power Revolution, the PBA also undertook its own efforts at restoration. It found its new home in Makati City, the new financial capital of our country.
In 1968, when the great earthquake destroyed our building in Intramuros, it became the leaning tower of Intramuros. And after a while, we filed cases against the contractor and the architect. And then the land was sold by our president then at the time, and the proceeds of which was used to buy our present office condominium.
And in keeping with the times, the PBA elected its first lady president.
My romance with the Philippine Bar Association started when Mr. Federico Agrava, that's the husband of Justice Corazon Juliano Agrava, invited us to be a member of the organized Philippine Bar. Pasita de los Reyes Phillips, who has been the treasurer for all these years, resigned as treasurer, and the board appointed me as treasurer. I accepted because for me, it's a big honor to be treasurer of such a very good organization. It took 19 years, or 17 or 18 years, when the Courtney and the lovable members of the board decided that maybe they should, after all these years of service, to reward me with something. And that's when they elected me as president of the Philippine Bar. At that, the first woman president of the Philippine Bar.
The history of the PBA is fundamentally intertwined with our nation's history. And as our history continues to be written, the PBA remains in constant watch, speaking truth to power and challenging the excesses of the rulers of the day, both in the real world or in cyberspace. We are the PBA, heirs to a glorious past, kindred in noble purpose, to blaze the future's path. Through time we have stood constant, faithful to our oath, champions of the oppressed, and guardians of the truth. We are the PBA. We stand for the rule of law.
Okay.
Malabas na kaya kay Kuya.
Ay, chef! No? Labas na kasando?
The year was 1891. Spain ruled the islands through the iron fist of Governor-General Valeriano Weyler. Ilustrados studying in Spain were in the midst of a second propaganda campaign. They published the newspaper La Solidaridad and wrote passionately about unity and self-determination. In Belgium, José Rizal published his second novel entitled El Filibusterismo. At home, a revolution was afoot. The year was 1891. Spain ruled the islands through the iron fist of Governor-General Valeriano Weyler. Ilustrados studying in Spain were in the midst of a second propaganda campaign. They published the newspaper La Solidaridad and wrote passionately about unity and self-determination. In Belgium, José Rizal published his second novel entitled El Filibusterismo. At home, a revolution was afoot, and a nation was about to be born. On April 8, 1891, Spanish lawyers based in Manila and those mentioned in the Spanish Royal Decree of 1891 were summoned to a meeting at the Real Audiencia in Intramuros. The purpose of the meeting, presided by Magistrado Eduardo de Ortuña, was the establishment of the Colegio de Abogados de Filipinas and the election of its first executive board. The Governor-General appointed José Juan Icaza as decano of the Colegio. And in that summer of discontent, one of the oldest associations of lawyers in Asia was established. The Colegio adopted its estatutos to govern the organization. It was granted juridical personality with powers to police its own ranks. A few years later, the Philippine Revolution broke out in 1896. Many members of the Colegio joined the fight for independence. Apolinario Mabini, a Colegio member, was regarded as the brains of the Philippine Revolution. Felipe Calderon, also a member of the Colegio, drafted a Malolos Constitution. As the Spanish Empire fell and American rule was established, American lawyers crossed the Pacific to practice law in the Philippine Islands. At the turn of the century, they organized themselves into an association of lawyers with ties to the American Bar Association. On June 24, 1904, under the inspiration of Chief Justice Cayetano Arellano, the Colegio de Abogados de Filipinas and the Association of American Lawyers in the Philippines merged, giving birth to the Philippine Bar Association. American lawyer Thomas L. Hardigan was elected as its first president. Among the members of the PBA at that time were Felipe Calderon, Gregorio Araneta, Rafael Del Pan, and Juan Sumulo. In 1924, Jose Abad Santos was elected president of the PBA. He was later appointed Secretary of Justice and Chief Justice of the Supreme Court. In 1942, while serving as the nation's caretaker during the occupation, he was captured and executed for refusing to collaborate with the Japanese invaders. On February 24, 1945, as Manila was bombarded by American forces during the War of Liberation, the PBA building in Intramuros was turned into ruins. With our nation rising from the ashes of the horrible war, the PBA helped in the task of rebuilding our legal institutions. On August 1, 1946, the canons of judicial ethics were adopted upon the proposal of the PBA. The decade following our independence saw a fervent tide of nationalism sweeping our land. It was a time for a rebirth. On March 27, 1958, prominent Filipino lawyers incorporated the Philippine Bar Association as the direct successor of the Colegio de Abogados de Filipinas. In recognition of the importance of the rule of law in our national life, in 1959, President Carlos P. Garcia proclaimed September 19 of each year as Law Day throughout our country. To this day, the PBA commemorates Law Day each year as a reminder that we are a nation ruled by law and not by men. It also marks the annual transition in the association's leadership. In 1966, the PBA returned to Intramuros and built itself a new home. But the great earthquake that shook the capital in 1968 reduced the PBA building to rubble.
I joined the Philippine Bar Association in 1968 at the product of my friends in the law practice, including Ike Bello, Gonzalo Gonzalez, and Dick Romulo. I also thought that it would be nice to join an association and be associated with the legal luminaries of the time, including Abad Santos, Recto, Delgado, and Tadjana, whose names are now legendary.
The 1970s saw a nation torn with strife and the rise of a ruthless dictator. The PBA was among those who condemned the imposition of martial law and the brutality that followed. In the dark years of the dictatorship, the PBA stood watch, investigated human rights violations, and against tremendous odds won cases for those illegally detained. In 1983, the PBA joined the nation in mourning the assassination of Senator Ninoy Aquino. As our democratic institutions were gradually restored following the 1986 People Power Revolution, the PBA also undertook its own efforts at restoration. It found its new home in Makati City, the new financial capital of our country.
In 1968, when the great earthquake destroyed our building in Intramuros, it became the leaning tower of Intramuros. And after a while, we filed cases against the contractor and the architect. And then the land was sold by our president then at the time, and the proceeds of which was used to buy our present office condominium.
And in keeping with the times, the PBA elected its first lady president.
My romance with the Philippine Bar Association started when Mr. Federico Agrava, that's the husband of Justice Corazon Juliano Agrava, invited us to be a member of the organized Philippine Bar. Pasita de los Reyes Phillips, who has been the treasurer for all these years, resigned as treasurer, and the board appointed me as treasurer. I accepted because for me, it's a big honor to be treasurer of such a very good organization. It took 19 years, or 17 or 18 years, when the courtly and the lovable members of the board decided that maybe they should, after all these years of service, to reward me with something. And that's when they elected me as president of the Philippine Bar. At that, the first woman president of the Philippine Bar.
The history of the PBA is fundamentally intertwined with our nation's history. And as our history continues to be written, the PBA remains in constant watch, speaking truth to power and challenging the excesses of the rulers of the day, both in the real world or in cyberspace. We are the PBA, heirs to a glorious past, kindred in noble purpose, to blaze the future's path. Through time we have stood constant, faithful to our oath, champions of the oppressed, and guardians of the truth. We are the PBA. We stand for the rule of law.
Good afternoon. Before we officially begin, may we ask Philippine Bar Association President Attorney Jose Perpetuo M. Lotilla to call this session to order.
Good afternoon. I hereby call this session to order.
Let us all rise for the singing of the national anthem, followed by the PBA hymn and the invocation by Attorney Ernestine Villarreal Fernando.
Mga kababayan, ang pambansang awit ng Pilipinas. Kayang mag-ibig, kaya sa sigatanan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, kuya ka ng mag-ibig, sa manlulupin, di ka pasisigil, sa nagatak tutok sa simoy at sa langit ng bagaw, ay hinatang tulakawin sa pagkayang minamahal. Ang isang ng matawad mo'y tagumpay na nagdidinig, ang bituin at karoon niya kailan pang ay di magdidinig. Luman ang araw ng walang pagsikta, buhay langit sa piling mo. Ang inigaya ng pagkay mga amin, ang mamatay ng dahil sa'yo. We are the PBA, heirs to a glorious past, kindred and noble purpose, to blaze the future's path. Let us be the shield against lies and oppression. Let us be the light to bring justice home. Through time we have stood constant, faithful to our oath, champions of the oppressed, guardians of the truth. Under our watch, let no one be denied. Under our watch, let no one be deprived. Our fight for justice is a fight that we shall wage with fervor and honor to the very end.
We lift ourselves in the presence of the Lord. We thank the Lord for gathering us together as colleagues in the rule of law, as friends and as family in pursuit of the purposes of the Philippine Bar Association. Please bless those gathered here and their families, especially during this time of COVID-19. Please guide all of us during this landmark webinar of the PBA. Bless the speakers, reactors, participants, and viewers who are sharing their time and ideas. Grant us the gifts of perception and respect. Grant us harmonious discourse, clarity of thought, wisdom, and above all, grant us kindness. For colleagues, for those who work with us, for our families. Dear Lord, we seek all of this through thy mercy. Amen.
All right, welcome everyone to PBA Talks. I am Pinky Webb, your host for this afternoon's webinar on mass media and the law. To give us an overview of this milestone event, let us hear PBA 2017 President, Attorney Fina de la Cuesta Tantuica's welcome remarks.
Good afternoon. Welcome to the maiden digital broadcast of PBA Talks, the Philippine Bar Association's fellowship platform in the time of COVID. PBA Talks was conceived to replicate PBA's regular fellowships, which, over the years, became a forum for the discussion of national issues that pertain to the rule of law. We shall hold that forum once again in a way that is attuned with the times. Our fellowship today has close to 1,000 attendees, composed not only of our own members and colleagues in the profession, but the public as well. For the first time, we shall hold our fellowship in partnership with the Harvard Law School Alumni Association of the Philippines and the Lyceum of the Philippines College of Law. We are in the midst of a global health crisis like no other, a pandemic that has significantly altered our way of life. Despite the physical constraints, however, we can still converge and discuss thanks to the miracle of digital technology. Against this new normal, an age-old clash has once again been brought to fore, that tension between government and press freedom. What with the trial court's conviction of noted journalist Maria Ressa, the NTC's closure of broadcast media giant ABS-CBN, Congress's denial of its franchise application, and the recent enactment of the anti-terror law with its all-encompassing definition of terrorism or terrorists. All of which leads one to ask, is government curtailing press freedom and the freedom of expression? This afternoon, we shall hear both sides of the issue from our speakers, Secretary Salvador Panelo, Chief Presidential Legal Counsel, and Dean Mel Santamaria, the Dean of the College of Law of the Far Eastern University. They will be joined by our legal luminaries, Dean Sol Mawis of the Lyceum of the Philippines University College of Law, as well as Professors Carlo Cruz and Rico Domingo, who are both professors of constitutional law at the Ateneo Law School and the Lyceum of the Philippines College of Law. We are fortunate to also have with us this afternoon veteran broadcaster of note, Ms. Pinky Webb, who will help us navigate our way through what we aim to achieve, an intelligent and fruitful discussion of an issue of national importance. Indeed, your PBA, which celebrates its 129th year this year, has come a long, long way. On behalf of the Board of Trustees of the Philippine Bar Association, PBA President Juju Lutilia, Harvard Law School Alumni Association's President Professor John Molo, and Lyceum of the Philippines College of Law Dean Sol Mawis. Welcome to PBA Talks.
Karangalan po namin na maglingkod sa inyo, kabayan. Hindi man na-renew ang aming prangkisa at pinatitigil ang ating broadcast, nangangako kami sa inyo, hindi kami mananahimik sa pag-ataking ito sa ating demokrasya at sa malayang pamamahay.
Is ABS-CBN Corporation Channel 2 in the service of the Filipino. Now signing off.
Wala pong sinasabi diyan na pwede kayong mag-launch ng multiple channels.
Mr. Chair, 5 taon na po namin binabroadcast yung additional channels na yun. Kung naging
kaya nga po kanina, sinasabi ko sa inyo, yung violation po nyo is more than 5 years already.
Patay na sa Kamara ang renewal ng prangkisa ng ABS-CBN. Yan ay matapos ibasura ito ng House Committee on Legislative Franchises.
Nag-ugat ito sa artikulong inilathala ng Rappler noong 2012 tungkol sa pagkakadawit umano ni Wilfredo King sa iligal na droga, human trafficking at murder.
Breaking news is that the Manila court has convicted Rappler CEO Maria Ressa of cyber libel.
She faces up to 6 years behind bars if the conviction becomes final.
Ang kaso po ng Maria Ressa, pribadong individual po ang nagkaso sa kanya. Hindi po gobyerno, hindi taong gobyerno, hindi politiko, pribadong individual. Nabasa ko na po ang desisyon. Ako naman po ay bihasang libel defense lawyer. May isang kaso, wala pa ako natalo. Nabubuhay po si Nines Cacho Olivares. No? Talagang minsan siyang na-convict, hindi ako naghawak. Pero I have absolved her in no less than 14 cases. Eh paano naman hindi mako-convict si Maria Ressa? Hindi naman sila nag-introduce ng evidence na wala silang mali.
Freedom of the press is the foundation of every single right you have as a Filipino citizen. If we can't do our jobs, then your rights will be lost.
Hindi pabor niyan yung mga lawbreakers, yung mga lawless. Pero yung mga matitinong tao, kasangga nila yung bill na yan.
With 173 affirmative, 31 negative, 29 abstention, House Bill number 6875 is now approved on third and final reading.
Payag ba kayo na arestuhin ng walang warat? Kasama yan doon. At payag ba kayo na makulong ng 14 days hanggang 24 days na walang kaso? Kasama yan.
All right, I'm going to do my best to moderate and navigate this discussion, but I'd like to thank Attorney De La Cuesta Tantuico. I'm honored to host and moderate this webinar, a first in a series of PBA talks this year. The Philippine Bar Association event is made possible in coordination with the Harvard Law School Association of the Philippines and the Lyceum of the Philippines University College of Law. Okay, let's get started. Against the backdrop of a life-threatening pandemic, the age-old clash between media and government has come to the fore. Thus, we need to examine the various aspects of this clash in the interest of vigilance against looming violations of the rule of law. On today's PBA Talks, mass media and the law is government weaponizing the law against media. We'll be focusing, as you saw, on three timely and controversial issues. The first, the non-renewal of media giant ABS-CBN's franchise. Number two, the conviction of cyber libel of Rappler's Maria Ressa. And the third, the enactment of the Republic Act 11479, or the Anti-Terrorist Act, which critics say has an overbroad definition of terrorists or terrorism. Are these events signs of the law's creeping weaponization to thwart press freedom and freedom of expression? To answer this question, we have two main speakers with opposing views on the matter. Each of them will be given 15 minutes to present their views. We have a panel of three reactors that will present their assessment on the position taken by the speakers. The reactors will have 8 minutes each to give their comments. So we are streaming on Facebook Live. I'm also glad to announce that we have over 1,000 webinar attendees. And we also have colleagues and friends from the media covering this event. We encourage you to key in your questions to our speakers and reactors in our chat box, because we will have an open forum in the second half of our 2-hour webinar. And we will be reading some of your comments and have our speakers answer your questions. To introduce our first speaker, we have PBA member, Attorney Bea Villegas.
This is Beatriz Villegas, member of the Philippine Bar Association and president of the Maritime Law Association of the Philippines. I have the honor of introducing our first speaker, who happens to be a very close and a longtime friend. Secretary Salvador S. Panelo serves as the Chief Presidential Legal Counsel of President Rodrigo Roa Duterte and a member of the Cabinet. He previously served in a concurrent capacity as the presidential spokesperson. He is married to Dr. Araceli Abrubina Panelo, an internist, diabetologist, and chairman of the Institute for Studies on Diabetes Foundation, a medical school for doctors who want to specialize in diabetes. They have 4 children: Ramona Francesca, an interior designer and medical pharmaceutical researcher; Salvador Paulo Jr., a corporate lawyer and senior partner of the Panelo Law Office; Salvador Carla III, a special child, his favorite and is deceased; and Salvador Angela IV, a resident physician in internal medicine in UERMM. Prior to entering public service, Secretary Panelo was an active law practitioner and handled high-profile cases. He lawyered for the former First Lady Imelda Marcos, former President Gloria Macapagal Arroyo, former Ombudsman Mercedita Gutierrez, former COMELEC Chairman Benjamin Abalos, former Davao City Mayor Rodrigo Roa Duterte, Davao City Mayor Sara Duterte, and other prominent and controversial personalities. He is an alumnus of the University of the Philippines College of Law and a member of the Sigma Rho, an exclusive UP Law Greek fraternity. Secretary Panelo also joined the academe and taught constitutional, criminal, and remedial law at the College of Law, the University of the East, Philippine Women's University, and the Pamantasan ng Lungsod ng Maynila. Secretary Panelo was also a broadcaster and political commentator in DZEC, Eagle Broadcasting Corporation, DZMM, ABS-CBN, and DWBL. He is currently hosting the public service television show Digong 8888 Hotline and the television talk show Counterpoint, both aired over PTV4 and RTVM at 8 p.m. every Friday and at 2 p.m. every Monday, Wednesday, Friday, simultaneously shown in Facebook live streaming, respectively. He currently writes a column in the Daily Tribune on its Monday, Wednesday, and Friday issues. Secretary Panelo has also held musical concerts. He composes the melody as well as the lyrics of ballads. His hobby includes playing the piano and tending his bonsai garden consisting of 300 pieces of various species. Let us please welcome Secretary Salvador S. Panelo.
Greetings and good afternoon to the Philippine Bar Association, President Jose Lotilla, its former President Fina Bernadette de la Cuesta Tantuico, its officers and members, as well as to my co-speaker, Dean Mel Santa Maria, to the panel of reactors, Lyceum Dean Soledad Margarita Deriquito Mawis, Lyceum Professor Carlo Cruz, PBA First Vice President Rico Domingo, and to the moderator, Ms. Pinky Webb, as well as to Maritime Law Association of the Philippines President, Bea Villegas, as well as to all fellow lawyers, law students, media practitioners, and netizens who are attending the webinar entitled Mass Media and the Law. Is the government weaponizing the law against media? It is my distinct pleasure to join you this afternoon to discuss a topic which has been a favorite of critics and detractors of this administration. to tap in there and seizing tirades against the president's policy of enforcing the law equally to all. Let me stress at the very outset that President Roa Duterte believes in the important role the press plays in our great democracy, as he considers the fourth estate as our partners for genuine change. As he himself said to the members of the media, by paraphrasing the words of Evelyn Beatrice Hall in her book entitled The Friends of Voltaire, I may not agree with what you have to say, but I'll defend to the death your right to say it. The Duterte administration does not condone media violence and repression of information. The president, for example, issued and implemented orders which promote freedom of information within the executive department, which beef up the protection of media workers through the creation of a task force on media security during the first months of his presidency. The president also signed Republic Act 11458, which improved the SOTO law, RA number 53, by expanding the coverage of those who may not be compelled to reveal their source of published news or information when the same was obtained in confidence. Another manifestation of how the chief executive holds the constitutional guarantee on the freedom of the press. In August last year, the social weather stations revealed the results of a survey it conducted in June of the same year, showing that 59% of the Filipinos agreed with the statement that I can say anything I want, openly and without fear, even if it is against the administration, with 67% of Filipinos concurring that mass media in the Philippines has freedom of speech, of expression, and of the press. I note that the results of the survey conducted by SWS in July of this year, where it found that 51% of adult Filipinos agree with the statement, it is dangerous to print or broadcast anything critical of the administration, even if it is the truth. Compared to the survey last year, however, the net agreement on the statement even eased by 10 points from strong plus 31 in June of 2019 to moderate plus 21 in July of 2020. At any rate, we are curious as to why 51% of Filipinos believe this to be so, for the president respects criticism as long as the same is not baseless, unfounded, or false. The president's record of not filing any libel case against any member of the media in his more than 50 years speaks for itself. As we say in law, res ipsa loquitur. Undeniably, dissent against this administration and its policies is loud and uncurtailed. Statements of disagreement, objection, or protest vis-a-vis the government are unceasing and widespread in all channels of media, including those in social media platforms, reaching the global audience. This despite the strong probability that such manifestations of dissent may come from a minority percentage of Filipinos who distrust or disapprove the president in his policies. Let me stress, there is no such prior restraint or subsequent punishment for those who wish to practice the freedom to dissent under the Duterte presidency. As long as the speech or expression is within the ambit of constitutional guarantees, it shall not face any government interference. Despite the gains of the administration it has achieved in the aspect of media as well as in the right of practitioners to press freedom, there are still those, however, who paint the president as one who does not tolerate dissent. Recently, these haters, including foreign organizations which are not even cognizant of our municipal laws, have cited the conviction of rappers Maria Ressa and the closure of ABS-CBN as instances of government weaponization of the law. The case of Ressa, who is very obviously basking in the global limelight as an outspoken Duterte critic, has nothing to do with press or media freedom. As I've repeatedly said, it is a case of accountability. The case against her was filed by Willie Kang, a private individual, an assertion of a citizen's right to seek redress before the law, without Ressa presenting evidence to overturn the presumption of malice or rebut the proof of actual malice. She, as determined by the court, abused her right to free press due to Rappler's publication of a malicious article. Necessarily, she must face the consequence of her felonious act. That's notwithstanding the conviction, the continued and impeded attack of Ressa against the Duterte administration makes her a walking testament of the robust freedom of the press in the land. I note that the results of the recent survey of SWS revealed that 56% of adult Filipinos consider the non-renewal of ABS-CBN franchise a major blow to press freedom. This is understandable given the propaganda undertaken by the critics who forcefully exploited the issue and associated the same with the president. However, I repeat that this is not an issue of press freedom. It is about the expiration of and failure to obtain a franchise. The remarks of the president against ABS-CBN are mere utterances of displeasure, which utterances are covered by the free speech clause of our Constitution. Arguments that these remarks influence Congress is inconsequential. Aside from the president accepting the apology of ABS-CBN, the decision to grant or deny a franchise lies solely the members of Congress. They ought not to be persuaded by outside forces, and jurisprudence is replete with cases holding that a franchise is a mere privilege and not a right. And in view of this, the executive branch cannot and certainly has never meddled, nor will meddle, and will never interfere with the affairs of a co-equal, separate, and independent branch of this government, of the government. Enforcing the law equally to all is not the same as weaponizing the law. The problem with critics and detractors of the president is that they have not been used to witnessing the law being applied to influential media people like Ressa and powerful media corporations like ABS-CBN, who remain critical up to this day. Truth to be told, they, together with other media outlets and practitioners, have been more critical of the government lately. The recent passage of the Anti-Terrorism Act of 2020 has also received widespread criticism, some of which point that the law would be used to deter media dissent. They forget that now, more than ever, violent extremism and radical but extreme illegal movements are widespread. They overlook the fact that terrorism has no respect for any country, race, religion, and ideology. When it treacherously strikes, it leaves a trail of blood, of thousands of deaths, and a graphic image of the incalculable destruction of properties. But on cue, you notice their discordant voices unite to demonize the ATA. They peddle a phantom of fear, of presumed would-be draconian enforcement, and lend their shrill and hysterical deceptive narratives. They foist the boogie that RA 11479 was enacted for no other purpose than to zip their lips, and those of media critics. Contrary to the suppositions of these cynics, the ATA does not broaden the term terrorism. Rather, it defines precisely and accurately based on what the world has seen apropos the acts of, as well as stratagem of these terrorists, which they use in unleashing their lethal force on their targets. In fact, it provides an exclusive listing in order that government enforcement agencies will be educated that all actions not identified therein should not be tantamount to terrorism. As we learn in law, expressio unius est exclusio alterius. The express mention one person, thing, act, or consequence excludes all others. What the law does not include, it excludes. More importantly, the defined terroristic act must be done to intimidate the general public or a segment thereof, create an atmosphere or spread a message of fear, to provoke or influence by intimidation the government or any of its international organization, or seriously destabilize or destroy the fundamental political, economic, or social structures of the country, or create a public emergency or seriously undermine public safety before the same can ripen into the crime of terrorism. Let me reiterate, it cannot target dissenting media practitioners, for the law specifically states that terrorism is penalized thereby does not include, quote, advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights which are not intended to cause death or physical harm to a person or to endanger a person's life or to create a serious risk to public safety, unquote. The provision penalizing the crime of inciting terrorism, Section 9, is relevant to today's discussion, as some has argued it to be a derogation of the freedoms of speech, expression, and the press. According to them, the definition of the offense is overbroad and vague, and that even legitimate forms of dissent can be misconstrued as terroristic acts. But this contention is misplaced. They forget that the act of penalizing the action of inciting to another to commit a felony is not a new notion or principle. The revised penal code has long penalized such actions when they threaten the country's national security or public order. In the said code, there are Articles 118, which is inciting to war, giving motives for reprisals. Article 138, inciting to rebellion or insurrection, and Article 142, inciting to sedition. We never heard them complaining about these felonies. The provision on detention without judicial warrant of arrest, Section 29, which is the most criticized among the provisions found in the Anti-Terrorism Act. Critics highlight this provision for permitting a warrantless arrest against a suspected terrorist whose detention could extend to a total of 24 days. Some also argue that this provision grants the ATC the authority to determine probable cause for the arrest of a suspected terrorist. This provision does not give a blanket authority for law enforcement to cause a warrantless arrest relative to the offenses mentioned therein. It does not state that a warrantless arrest may be effected against any suspected terrorist. It only presupposes or assumes that a suspected terrorist has been arrested already without a warrant, as the provision governs the period to file cases against them pending their detention. It is for this reason that Rule 113, Section 5, the Rules of Court on allowable warrantless arrest must still be observed. In fact, allowing warrantless arrest is not what this provision for. What is this provision for? The essence of this provision is to penalize the delayed filing of cases against persons taken into custody without a warrant. The longer duration of detention of 14 days is justified by reason of the nature of the extraordinary crime of terrorism and by force of necessity. And if you compare this provision with other countries having same anti-terror measure, our period of detention is shorter than theirs. Look at our neighbors in Asia. Bangladesh permits 15 days of detention. In Indonesia, detention is permitted for 21 days, which can be even extended for an additional 20 days. In Pakistan, it allows detention up to 30 days. In Malaysia, detention can be from 59 days up to 2 years. Finally, we have Singapore, allows 730 days of detention and may be extended, would you believe, indefinitely. The critics keep raising the issue that the finding of a probable cause preliminary to the arrest of suspected terrorists, which presently is given by law to a court judge, is now being placed to the Anti-Terrorism Council. This is a wrong interpretation of this provision. You must remember that under Section 45 of ATA, it specifically provides that nothing in this law shall be interpreted to empower the ATC to exercise any judicial or quasi-judicial or authority. The phrase, any law enforcement agent or military personnel who, having been duly authorized in writing by the ATC, has taken custody of a person suspected of committing any of the acts defined and penalized by ATA, simply means that the law enforcement agent or military person has been authorized previously by the ATC to conduct operations or surveillance against terroristic acts pursuant to Section 16 and 17 of the ATA, after the Court of Appeals has already issued the authority to conduct surveillance activities, but definitely not to cause the arrest of a predetermined particular or named suspect. It is still the law enforcement agent or military person who will determine if a warrantless arrest in accordance with our prevailing doctrines may be pursued under the circumstances on the ground of its case. Aside from the ATA demonstrating constitutionality and a legitimate purpose to counteract of terrorism, the same law contains sufficient safeguards to protect the human rights of our general population, including members of the press and the media, and to prevent abuses on the part of government agents. This aside from the civil guarantees under the 1987 Constitution, as well as relevant laws that provide remedies to citizens, such as availing protective writs from the courts of law. We have petition for writ of habeas corpus, petition for a writ of amparo. Then you can file a petition for bail. The first of critics and detractors, including those belonging to the media industry, are those more imagined than real. I therefore reiterate the President's call to Filipinos not to hesitate in articulating their thoughts on government policies, critical or otherwise. Ours is a President who not only respects everyone's right to free speech or press, but listens to our plight as he ensures that the fibers of our country's democracy are preserved and enhanced. And if you only look at the newspapers, you listen to commentators, freedom of the press and of the speech is so robust in this country. With this, let me end my speech by quoting the President in one of his addresses to media practitioners last year. As an important conduit between government and the people, you in mass media are tasked with the sacred responsibility to ensure the truth and fairness will prevail in the delivery of information to the public. Rest assured that the government will never waver in its duty to uphold press freedom, to promote free speech, cultivate a safer environment for journalists, even as we work together in safeguarding our democratic institutions. Together, let us join hands in shaping a more progressive and well-informed citizenry who will work with us in building a stronger Philippines. Again, I thank you and congratulations to the Philippine Bar Association for spearheading this event.
All right, thank you to Chief Presidential Legal Counsel, Attorney Salvador S. Panelo. Let's go now to our next speaker to introduce our second speaker. Let's call on Far Eastern University Institute of Law Associate Dean Anthony Gocwinco.
Distinguished guests, ladies and gentlemen, good afternoon. It is my distinct honor and privilege to introduce one of the speakers for the Philippine Bar Association's webinar on mass media and the law, my former professor at the Ateneo Law School and the current dean of the Far Eastern University Institute of Law, Attorney Melencio S. Santamaria. Dean Santamaria obtained his Bachelor of Laws with honors from the Ateneo de Manila University School of Law in 1982. In 1987, he graduated with a Master of Laws degree in Banking Law from the Morin Center for Banking Law Studies at Boston University School of Law. He was also a Fellow of the International Law Commission in Geneva, Switzerland. He began teaching at the Ateneo Law School in 1986 and has been teaching there ever since. In November 2013, he assumed the deanship of the Far Eastern University Institute of Law. Dean Santamaria also teaches at the Pamantasan ng Lungsod ng Maynila, the University of Santo Tomas, and the San Beda Graduate School of Law. He formerly taught at the University of Asia and the Pacific School of Government, Adamson University College of Law, and the San Sebastian College of Law. He is also the Vice Chair of the Department of Areas of Special Concerns of the Philippine Judicial Academy of the Supreme Court of the Philippines. His legal expertise has resulted in his being engaged by the Supreme Court of the Philippines as amicus curiae. He has also appeared before the Senate and the House of Representatives as a resource person for a variety of legislative matters. Dean Santamaria is also a published author with 3 law textbooks: Persons and Family Relations, Court Procedures in Family Law Cases, and Obligations and Contracts, Text and Cases, all of which are available at Rex Bookstore. He has also written 3 books on politics and current events: Read My Mind, What's the Point, and Beyond Dissent, which are all available at all national bookstore branches. Dean Santa Maria, or Dean Mel as he is known to his students and peers, is also an accomplished broadcaster and columnist. He hosts the radio TV show Relasyon on Radio 5, 92.3 News FM, which is simulcast on Television Channel 1, also known as 1PH on Signal Cable TV from 1 to 2 in the afternoon, Monday to Friday. He also has his own YouTube channel, Attorney Mel Santa Maria. Dean Santa Maria was awarded the Kapisanan ng Broadcaster ng Pilipinas, KBP, Best Public Service Host for Radio in its 23rd KBP Golden Dove Awards in 2015. He also received an award for the same category at the 2019 3rd Guilds of Educators, Mentors, and Students, or GEMS, Hiyas ng Singing Awards. Dean Santa Maria writes a column entitled Just Saying for Rappler. He previously wrote a column, Pay-Per-View, for the Manila Bulletin and was also a contributor to Interaction. He's married to Professor Amparita Santa Maria, the director of the Graduate Law Program of the Ateneo Law School. They have 3 children. Ladies and gentlemen, Dean Melencio S. Santa Maria.
Thank you very much to all of you, to the officers of the Philippine Bar Association. And it's an honor to be here with Secretary Sal Panelo. Thank you very much. Is government weaponizing the law against media? The question posed is an issue of tension between 2 entities, a tension which ought to be constructive, but is turning out to be destructive one way. It involves the government and the press. The Constitution grants the government and its officials enormous express and implied powers, but with respect to the press, only a reference under the Bill of Rights, but a reference which is imperative in a democracy. From a fundamental perspective, it is between the powerful government and the comparatively a powerless press. Needless to state, the power is granted by law, such that whenever public officials abuse power, in effect, those officials weaponize the law that grants them that power. One of my favorite quotes is that in a democracy, there must be a, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, unquote. And also, government officials are property of the public, and that they should not be thin or onion-skinned. And because the press has only its pen, paper, microphone, and cyberspace to legitimately criticize the government, and considering that the government, particularly the executive department, is charged with the law's execution using the police, the military, its hundreds of prosecutors, its allies in the legislature, both lower and upper houses, and the judiciary, indeed all the mighty panoply of all government powers. It is a given that in that tension, the press will always be in the receiving end. And so that is why the freedom of the press, alongside the freedom of expression and the right to petition the government for the redress of grievance, is enshrined in the Bill of Rights. That is also why Article 32 on damages resulting from violation of constitutional rights has a special place in the Civil Code. And that is also why the Supreme Court said that with respect to violations of these rights, good faith generally is not a defense. During his sponsorship of the Bill of Rights, Father Joaquin Bernas of the Society of Jesus, the foremost and most erudite constitutionalist of our time, was asked, the protection of fundamental liberties is the essence of constitutional democracy. Protection against whom? Bernas replied, protection against the state. In an autocratic government, the press is the first target for repression. In a democratic government, only the high bar of clear and present danger can curtail the freedom of the press. So to curtail it, clever maneuverings through the legal system is utilized to give an ostensible appearance of propriety. That is why, because of this semblance, we must not be deceived by its pretentiousness. We must discern every situation, taking into consideration its rightful context. Are we in such a situation, or at least dangerously nearing it? Is the press at the moment imperiled? My answer is yes. Worse, the attacks, both subtle and overt, are undertaken using legal processes like, in effect, making a mockery of these processes. The facade may be technically legal, but the underpinning motivations and the consequent result is unconstitutional against public policy, morals, or good custom. Going simply legal is not the measure of non-abuse of right or the negation of a wrong. In a number of cases, the Supreme Court ruled that simply, and I quote, going legal is no defense for wrongdoing if in the exercise of one's rights and in the performance of duties, one does not act with justice, give everyone his due, and observe honesty and good faith. Now let us look at the landscape. The ABS-CBN situation is the macrocosm of a frontal attack against the free press. The microcosm being the conviction of Rappler's Maria Ressa for an alleged crime many believe to have already prescribed, not to mention the many other cases filed against her. Some people say that the Maria Ressa cases have nothing to do with the press. But you must not view these cases in isolation. There must be context. As the open letter in defense of press freedom signed by Princeton's alumni, published in the Washington Post on July 21 said, and I quote, the phoniness of the charges against Maria are underscored by the absurd number of them. In 2018, she and the innovative news outlet she founded, Rappler, were hit by 11 separate legal complaints. Last year, Maria had to post bail 8 times in order to stay out of jail, unquote. And again, who is involved? Maria Ressa. Let us not forget, President Duterte, without mincing words, accused her publicly as, quote unquote, a fraud. When the highest and most powerful official of the land, with all his pervasive influences, singles out and threatens one person with so many years of journalism experience in CNN, ABS-CBN, and now Rappler as a reporter, writer, director, and producer of news, who wrote for the Wall Street Journal and taught Southeast Asia politics and the press in Princeton, and broadcast journalism at the University of the Philippines, was a recipient of numerous journalism awards by prestigious international press associations. Then you are dealing with the very issue of journalism and therefore the press. For who else is the press but the individual persons constituting it? And when the National Union of Journalists of the Philippines released an official statement which said that the DOJ, quote unquote, perverted the law by charging Maria for an offense, concluding that it is part of the administration's strategy, quote unquote, to intimidate the rest of the independent Philippine media in towing the line, unquote, we have to seriously consider what it says. NUJP, 30 years in experience, knows the terrain better than many of us. In March 20, 2017, President Duterte said, and I quote, Inquirer, mga bullshit kayo, pati ang ABS-CBN, basura yung ina nyo. Dapat may magsabi sa inyo ngayon, may blip ninyo, sinosobrahan nyo ang kalokohan nyo. Unquote. That is a veiled threat, a grotesque form of unjust vexation. And because he knows, I presume, and I assume, as president, he is absolutely immune from suit on the basis of jurisprudence, which is part of the law of the land. He is uninhibited. In my opinion, this is a form of weaponizing the law, a legal right abused to the maximum to cause fear, using legal immunity pursuant to the law, and in effect weaponizing that law. But regarding ABS-CBN, he warned in 2019, ang iyong franchise mag-end next year. If you expect ma-renew yan, I'm sorry. I will see to it that you're out. Unquote. In my opinion, that is a threat and that is abuse of power. He makes impromptu statements laced with invectives with impunity because he knows he has immunity accorded by law. That, in my opinion, is weaponizing the law. The justification is that a franchise is a privilege, and therefore, since the House of Representative Committee was given power to conduct the proceeding, then everything is legal. But again, context. When power granted by the Constitution is exercised not in consonance with constitutional policies and principles, and with the existing compelling factors like the pandemic, especially when the grounds for rejection of the franchise are so flimsy, as we have all read, such exercise results in oppression and unjust consequences, even if a quote-unquote legal proceeding was undertaken. Remember what I said a while ago, that the abuse of power granted by law is weaponizing that law? When that occurs, harassment happens. And there are just a number of harassments by state agents, not all, but some, that are not well publicized but documented by both the Center for Media Freedom and Responsibility and the NUJP. For example, the Center for Media Freedom and Responsibility reported that Radio Natin Gimba in Nueva Ecija has been receiving threats from its LGU, quote-unquote, allegedly prompted by the radio stations reporting of LGU's response to COVID-19, including some complaints from Gimba citizens, unquote. CMFR also reported that police confiscated issues of Pinoy Weekly magazine during a raid in Pandi, Bulacan on 20 July 2020, claiming that publication is illegal and carries anti-government propaganda. When asked for a search warrant, the authorities could only say, well, it is illegal. And also we have heard of the police using, quote-unquote, the direct assault weapon, and a crime under the revised penal code as ground for an arrest, even in the simplest complaint by a person to be arrested. That is weaponizing and abusing the law. And talking about abuse of right, we must not forget the case filed on April 11, 2019 with the Supreme Court questioning Malacanang's decision banning Rappler reporters from covering news in Malacanang, joined in by 41 reporters, columnists, and anchors from different media organizations. Malacanang, through the OSG, reasoned that Rappler did not meet the accreditation requirements. Analyze this in the context of the president's anger against Rappler, even getting personal, condescendingly chiding that Rappler reporters have armpits with bad odor. Then the credibility of the reason crumbles. The remedy is just to correct the inadequacy if there is any. How hard could that be? And the newest weapon of all is already law, the Anti-Terrorism Act. When the law expressly combines the clear threshold of mere suspicion with the extremely vague and overly broad definition of the various offenses for which a person can be arrested on the basis of that suspicion, government and law enforcers shall have a heyday using their own boundless imagination in arresting any person. Simply, whatever their minds can conjure will be their law. Arbitrariness and capriciousness will be the order of the day. The rule of law eroded. The signs are portentous. It was reported that Armed Forces of the Philippines Chief of Staff Lieutenant General Gilbert Gapay wanted the use of social media regulated under the IRR of the Anti-Terrorism Act. That is so repulsive, prompting Senator Drilon to say, quote and unquote, that will go beyond the real intent of the law and therefore it is illegal and unconstitutional. Unfortunately for Drilon, he is now helpless. Legislation is over. The bill is now law. He can only voice out his objections but cannot prevent its inclusion in the IRR as suggested by the AFP chief. One has to go to the Supreme Court if his or her rights are violated. But in the meantime, regardless of whether or not the repulsive suggestion is heeded, anyone, especially the press, can be jailed for 24 days without charges on the basis merely of suspicion and written authority from the Anti-Terrorism Council. Remember, the anti-terrorism law expressly provides in Section 29 thereof that mere suspicion of the commission of crime is enough, also without written authority from the Anti-Terrorist Act. And you know, the phrase suspected of commission was repeated 8 times in the law. And so that therefore we know that it is an intended provision, intended word, suspected. Alam naman natin lahat ng ibig sabihin ng suspected eh, hinala. And there is a provision in the Anti-Terrorism Act, Section 3, defining words which are not clear. Nothing is there to define suspected. And therefore, suspected must be understood in its very literal sense. Nasuspetsahan lang. 8 times repeated in the law. And it is very clear that there are 2 cases provided by the law. Suspected and charged. Those are 2 different situations. And these are provided in Section 16, 30, 46F, Section 52, 53, Section 3C, 16C, 29 twice, 30, 32, 46, 28. Suspected or charged with. Suspected or charged with appears in Section 16, 30, and 46F. And so we know exactly that there are 2 situations. One mere suspicion and one charged with. Madaming makukulong na journalist at reporters dyan. And I could go on talking with the anti-terrorism law. And we have filed a petition. I'm one among them with the Supreme Court. And I've studied that law, and it is really dangerous for the Filipino people. I end with a quote from Montesquieu. He said, "There is no crueler tyranny than that which is perpetuated under the shield of the law and in the name of justice." Maraming salamat po.
Thank you to Dean Melencio S. Santamaria Jr. So now we have a lot of questions already, I myself included, but we need to proceed to the panel of our reactors assessment. Our first reactor is Lyceum of the Philippines University College of Law Dean Maria Soledad Margarita de Riquito Mauis.
Good afternoon, everyone. Good afternoon, Secretary Panelo, Dean Mel, Professor Cruz, Attorney Domingo, and all attendees. Okay. Deutsche Welle, Germany's international broadcaster, reported that in December last year, President Duterte said that ABS-CBN franchise will end next year. If you expect it to be renewed, I'm sorry. I will see to it that you're out. Months later, ABS-CBN's franchise was in fact out. Despite such pronouncement, the government through Secretary Harry Roque denied using pressure tactics against the media. As reported by the Taiwan News, the presidential palace has maintained a neutral stance on the issue of press freedom, as it respects the separation of powers between the two co-equal branches of government. Much as we want to work with the aforesaid media network, we have to abide by the resolution of the House Committee. Why is it that the non-renewal of ABS-CBN franchise elicit adverse reactions from the public when, according to our distinguished speaker, Secretary Panelo, the exercise of press freedom is not the issue in that case? According to Secretary Panelo, the executive branch did not and shall not meddle in the grant of franchise. Paraphrasing the language of the Supreme Court in the case of Philippines Today versus NLRC, a 1997 case, in appreciating a case, one cannot merely limit oneself to the literal meaning of the words and phrases used, but more importantly, one must take into account the peculiar circumstances attendant to its writing, as well as antecedent, contemporaneous, and subsequent actions. A complete and holistic view must be taken in order to objectively assess whether the government is weaponizing the law against mass media. With due respect, the conclusion is inevitable. One must not be surprised for such adverse reactions from the public because one, borrowing the language of the Supreme Court in the Philippine Today case, had more than enough sense to anticipate the consequences and effects of his words and actions. Indeed, what a man sows, he reaps. Not only the antecedent pronouncement of the president paved the way for the forming of the opinion that ABS was targeted, but his subsequent actions further confirmed the same. As reported by Inquirer.net, the president's reported verbal expression that he was very happy that he has dismantled the oligarchy in the country, and that without declaring martial law, he was able to destroy the people controlling the economy and the people who don't pay, is truly unnerving. Please do not get me wrong. If a person does not give the government what he is legally obliged to pay, then he must suffer the consequences of the law. But for a person to be targeted and identified as one who does not pay without affording the said person an opportunity to defend himself in the proper forum is anathema to his constitutional right to due process. It is simply becomes a conclusion bereft of factual and legal basis. In the article of Maria Pavlova of the McGill University, the author said that a weaponized legal regime is compatible with democratic political competition. In it, political competitors reach regularly for the law to undermine their opponents, strengthen themselves and their allies, or advertise their power. Marie Henin, a writer for the Globe and Mail, also wrote that historically, criminalizing others, locking them up, is a weapon deployed to maintain social dominance. Now, let's try to recall the case of Birago versus Philippine Truth Commission, a 2010 case. If you would kindly recall, the law was struck down as unconstitutional because of, among others, it targeted merely Arroyo administration. The law did not include past administration similarly situated. So therefore, according to the Supreme Court, it constitutes arbitrariness, which the Equal Protection Clause cannot sanction. According to the Supreme Court, such discriminating differentiation clearly reverberates to label the Commission as a vehicle for vindictiveness and selective retribution. Having had our own share of the law being used as a weapon of choice, the sectors of civil society, therefore, cannot be blamed for believing the rise of an unseen but much felt undercurrents of fear and anxiety. The law, which is supposed to guard the citizens from governmental vindictiveness, now label people's speeches, writings, proclamations, emblems, banners, and other representations as tending to incite terrorism as a criminal act. But when does the line of freedom of expression end? When is activism not terrorism? When is critical reporting or public grievance not inciting to terrorism? What is truly worrisome is that the law becomes the potential vehicle for vindictiveness and selective retribution. After listening to our distinguished resource person, I trust and pray that the law will not be used as a weapon, as a means to legitimize a party or a person's adventure in partisan hostility. Thank you very much, and mabuhay Philippine Bar Association.
Next up is Lyceum of the Philippines University College of Law Professor Attorney Carlo L. Cruz.
I have just unmuted myself. You'll have to pardon me for this thing. No? May I start by saying good afternoon. Good afternoon to everyone. No? It is such an honor for me to be in the company of such, I would say, among the best legal minds in the country. I refer, of course, to Dean Santa Maria, always dashing, to Dean Sol Mawis, my crush, and Professor Rico Domingo, crush ng bayan. I should say good afternoon also to Secretary Panelo, always dashing as well, always debonair, dapper, fashion icon for maybe Armani or Prada, maybe. Now, I did not come with a prepared speech because I was prepared to listen. This is my first time to be a reactor. So you'll have to pardon me if I go about it extemporaneously. No? My first reaction, may I start please with the statement, no? Panalo. Now, he mounted what would constitute facial challenges against the several measures which are the subject of this afternoon's proceedings. And I happen to agree with many of his statements. I will expound on this in a little bit. Now we go to the other side of the room, and I address the statements of the good and handsome Secretary Panelo. Let us say that a facial challenge was presented, and on the other side we have the challenge, no? Who spoke about the law, who spoke about the pronouncements of the president, his executive orders. First thing that I detected is this, no? Well, the acts, official acts of the president would seem to be not consistent with reality. You know, the legal arguments raised by the good secretary, they're fine, perfectly fine for classroom discussions. But I am here not just as a lawyer, but also as a citizen. My concern is not what are or what may be the subjects of discussion inside classrooms. My concern lies in what is actually happening out there in the streets. You know, there is this pronouncement that the president upholds freedom of the press, freedom of expression. And yet, as cited by the good Dean Santa Maria and also by the lovely Dean Mawis, no? ABS-CBN, the statement of the president, this is documented, you're out. Well, Rappler, remember that scene, that time? I saw the video footage when the president had this, confrontation with this very lovely reporter from Rappler, or another, and thereafter it snowballed. No, Rappler, fake, Reza, fraud, and then the SEC proceedings started, and then the libel suits were, well, what a coincidence, they were filed after that. No? Well, Dean Santa Maria was right. Only fairly recently, I saw on Facebook news reports to the effect that as a small newspaper outfit was closed down by the soldiers or by the policemen, I'm not sure anymore. No? So what I'm saying is this, the things that Secretary Panelo said, fine for classroom discussions, but they are actually inconsistent with what is happening out there in the streets. And there lies my main concern. So you see, there is this element of pinipersonal. No? Alam mo, pwede natin sabihin na lahat ng sinabi ni Secretary Panelo ay matagal nang binibenta. Pero alam nyo, sa tingin ko, walang bumibili. Precisely because the actions of this administration would not be consistent with their declarations. Well, uh, I am glad that Secretary Panelo pointed out the basic distinction between government and administration. Well, the title of this webinar says, is government weaponizing the law against mass media? My submission is this, no? I am glad that Secretary Panelo is able to distinguish between administration and government. Government is the permanent machinery. It is the perfect representative of the state. Now, it is manned by people, the administration. As defined, it refers to the group of individuals in whose hands the reins of government are for the time being. Now, here's a basic point that I would want to emphasize. No? We have seen that many of the men in this government today have actually weaponized the law. No? I recall a question propounded by the good and handsome Justice Leonen, #LoveGuru, when he, during the oral arguments in that De Lima versus Reyes case, no? Sabi ni Justice Leonen, what differentiates this case from the others? Of course, the main issue in that case was on the jurisdiction of the regional trial court over that drugs case. No? Well, you know, if I had been there to answer that question, it would have been this. What differentiates that case from the others? The other similar cases would have been the vindictiveness of this president. You recall that Senator De Lima, when she was the head of the Commission on Human Rights, well, she discovered about this Davao Death Squad. She went about into investigating this Davao Death Squad. When it angered the mayor, that mayor eventually became president. And that president said, I will go after you. He did. So you see, no, the personal element, no? Well, you have to understand, no, that in many other similar situations, which are really happening out there in the streets, no? I cite another illustration, no? Well, before I go to the negative, may I just cite the positive side? I would like to cite Secretary Panelo himself, no? You know, there have been many criticisms hurled against him when he said that public safety can be a ground for the declaration of martial law, when he said that the writ of habeas corpus can be suspended by the president. He was severely criticized by lawyers and law students when he said that this coronavirus can be considered as an invasion, which again can justify the declaration of martial law. Pardon me for this, Secretary, but I have to be blunt to emphasize my point. No? Many persons laughed at him. But look at Secretary Panelo. I am not aware that he has filed any libel suit against any of his critics. My thinking is this. It is precisely because I think he understands the Bustos principle, which simply tells us, and this is doctrine, that men in government should not be too thin-skinned. Kailangan medyo makapal ang balat and should not be easily hurt by these criticisms. Ang ginawa niya hanggang ngayon, as far as I know, ang ginagawa ni Secretary Panelo, lumalaban ng tapatan, no? Mano-mano. No? He does not use the law. That is good. I cite another recent example. This Secretary Anyo and his backrider barrier policy. Look at the statements on social media. No? Tanga, stupid, bobo. And yet, I am not aware that he has filed any libel suit. He has not weaponized the law at all. For purposes of going after his critics. This, I think, is good because like Secretary Panelo, Secretary Anyo most probably understands as well the Bustos principle. Well, that is fine. No, I place along their sides Vice President Leni Robredo, who has been subjected to such vilification. No? And also Risa Ontiveros, sana ma-rape ka sa Muntinlupa. What kind of statements are those? But then they understand that this is part of their functions or of their lives as public officers. They do not weaponize the law. Now, in contrast, no? Well, we have this congressman, Remulla, I think, no? When he disrespected the Philippine flag. Well, he was severely criticized for it. And what was his initial response? He was going to institute cyber libel suits against those who were bullying him on social media. Well, that to me is weaponizing the law. There is this Bongo, a senator, and also I think he's still a SAP, no, a special assistant to the president, because I find him more in Malacanang than in the halls of the Senate. No? Well, one, he invoked loopholes in the rules of the Senate when he refused to be interpellated by his peers. This is so anti-democratic. That is weaponizing the law. Huh? Well, you are aware of the NBI efforts to go after the critics of Senator Bongo. Well, there is this law office which has filed several complaints against those who have published on their social media accounts what Mr. Bongo claims as fake news. You know, this is a clear indication that he does not understand the Bustos principle, unlike the good Secretary Panelo and Secretary Anyo. Well, I have only 8 minutes. No? Those are among the main points that I would like to stress. But this is my final point. No? It is true, I agree, Mr. Secretary Panelo, that seemingly the measures of this government can be interpreted as presenting no prior restraint, as presenting no potentially subsequent punishment. My fear lies in this, and this has not been mentioned at all. These measures of government, as implemented by those who are given the task of enforcing these measures, they produce a chilling effect upon the citizenry. And you know, this chilling effect, well, effectively, it is prior restraint. Chavez versus Gonzalez, Chief Justice Puno. I'm sure you are aware of this particular decision. My main point is this, no? After given all of those illustrations, my main point is this. The administration mans the government, and the government equips it with power, with all monies, no? Appropriations. It has the power of the purse. It has military might. What do we, the citizens, have? All we have are our voices. Freedom of expression, at once the instrument and the guarantee and the bright consummate flower of all liberty. Would you deny us even that with your wrongful use of these measures available to you, with all the power and resources that are intertwined with your functions as government functionaries? So that is my reaction. Okay, thank you very much.
All right, I guess that should serve as a reminder to Secretary Sal Panelo not to file any case, libel case, cyber libel case against anyone. Otherwise, the statements of Attorney Cruz will be put in vain. Thank you to Attorney Cruz. Our third reactor is Philippine Bar Association Vice President, Attorney Rico V. Domingo.
Unlike my co-reactor, I'd like to be a little bit more sedate in describing my fellow speakers, because Professor Caloy is a very good friend of mine. That's why he calls me of that sort. But thank you very much, President, rather Secretary, future President Panelo, as well as Dean Santa Maria, together with the Dean Mawis, and of course our Professor Cruz. I'd like to preface my reaction to the salient points discussed in the main speeches by briefly revisiting the history of what we know now as the Speech and Press Clause of our Constitution. Very quickly, if you look at the history, our beloved Dean Emeritus of the Ateneo Law School and the foremost constitutionalist, Father Joaquin Bernas, in his treatise Commentary on 1987 Constitution, aptly observed that the freedom of expression was a concept unknown to the Philippine jurisprudence prior to 1900. And he refers to the First Amendment, which I quote, "The Congress shall not or shall make no law abridging the freedom of speech or of the press. That is what is commonly called the First Amendment. That particular clause of the First Amendment was engrafted in the 1935 Philippine Constitution under the colonial auspices of the American regime. When pursuant to the Tiding-McDuffie law, again, it was given imprimatur and with identical wording later on as the First Amendment and reproduced in the 1973 Philippine Constitution. And let's move on. In February 1986, after the EDSA Revolution, there was a 1987 Constitution drafted. And with the exception of the phrase of expression, the 1987 Constitution now states in Section 4, Article 3, that no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people to peaceably to assemble and petition the government for redress of grievances. These 14 words in the original First Amendment in the US Constitution provides the cornerstone for the rights of all media practitioners. Freedom of speech and of the press is a portentous phrase. It has been a catch cry of political dissenters, the vociferous chants of supporters after conviction of courageous publishers. It has been a slogan of pornographers and racial vilifiers. Thus, whenever a government official suggests that a newspaper columnist cannot write about a particular subject or threaten to prosecute someone for what he intends to write, or tries to regulate or tax that what he writes, the party adversely affected by such government actions must ultimately turn to the First Amendment, the Speech and Press Clause, to determine if such actions are constitutionally permissible. Among the venerable rights safeguarded by the First Amendment are what American Justice Brandeis called the freedom to think as you will and to speak as you think. And in Justice Brandeis' view, truth, quote unquote, is achieved not by controlling what is said, but rather by the free flow of information. And thus, Justice Brandeis wrote in 1927 that discussion affords ordinarily adequate protection against the dissemination of noxious doctrines. The thematic message underpinning this webinar is, as the title suggests, is the government weaponizing the law against media? Contextually, the term law in the First Amendment or the Speech and Press Clause of the 1987 Philippine Constitution is not limited to statutes or other acts of Congress, although clearly the courts have reviewed such laws to ensure compliance with the First Amendment. But all actions of the government, including the executive orders and rulings of the courts, such as the injunction after publication, come within the protection of the First Amendment. All lawyers will recall that Article 8 of the Civil Code of the Philippines provides that judicial decisions applying or interpreting the laws of the Constitution shall form part of the legal system of the Philippines. The recent developments that elicited cries of suppression of press freedom include the non-extension of the franchise of the ABS-CBN by the House of Representatives and the corresponding cancellation of its legislative franchise by the National Telecommunication Commission. An example of court ruling that inspired invocation of freedom of the press and of expression involves the recent conviction of Ms. Maria Ressa for online libel under the Cybercrime Prevention Act, which again underscores the damaging aspect of any attempt to restrain publication as a chilling effect on press freedom. In fact, even a threat of prosecution, as correctly said by Secretary Panelo, as well as the Dean Santa Maria, would effectively deter publication of what otherwise are newsworthy materials. The passage of the Anti-Terrorism Act, or the Republic Act number 11479, which took effect on July 18, 2020, the conviction of Ms. Ressa and the cancellation of the legislative franchise of ABS-CBN only highlight what appears to be an ageless battle, or if you will, collision between the First Amendment rights of the public and the press in a democracy and government's rights to maintain national security and defense, as our main speakers succinctly and forcefully argued. It has been suggested that the newly enacted Anti-Terrorism Act gives the government vast power to control the flow of information about the activities of the government, and that it is an all-pervasive piece of legislation. Opponents of the Anti-Terrorism Act insist that it cannot or should not pass muster judicial scrutiny, given that our country has consistently demonstrated a historical abhorrence to imposing any governmental restraint on speech and expression. This appears to be the crux of the 29 or so petitions now pending with the Supreme Court challenging the constitutionality of said legislation. Proponents of the anti-terrorism law expectedly say otherwise, insisting that the state has an inherent right to self-preservation. It is submitted, though, that any built-in legal mechanism embedded in said statute carries a heavy presumption against constitutionality. In closing, what I find disquieting, a feeling which I am sure is shared by the ordinary citizens of this country, is the administration's increasing and overly reliance on key governmental officials and executives whose main background is rooted in their experience in the military and police rather than in civil governance. These are the officials currently being tasked to implement and enforce the law. The composition of the COVID-19 Interagency Task Force and the composition of and the participation of key cabinet positions are just few examples of such phenomenon. If the laws are to be weaponized, as the term is used in the context of this webinar, let the laws be used properly in accordance with the higher and salutary virtues of the rule of law. The laws should not be weaponized based on who is wielding them, how such power wielder does it, and why. And this circumstance led Mr. Justice Potter Stewart to say in his address to the Yale Law School in 1975, and I quote, "The Constitution particularly the First Amendment of freedom of press. In other words, establishes the contest, not its resolution. Congress may provide a resolution, at least in some instances, through carefully drawn legislation. For the rest, we must rely, as so often in our system we must, on the tug and pull of the political forces in the society. Thank you and have a good day.
Thank you to Attorney Rico V. Domingo. At this point, we need to take a break. There's going to be a 3-minute break. Let's rest for a bit. After that, we'll be back for our open forum. I have all your questions and I will read them in order as they first came in. So we'll see you back after 3 minutes.
Once upon a time, I put a Facebook status on, and I asked, what would you do if you were leader for just one day? Kung ikaw ang presidente ng Pilipinas, anong gagawin mo para sa iyong bayan? People commented on my status, and I promised I took only the most positive comments and turned it into the lyrics of this song. Love for country above all else. This is a song called Leader for a Day.
If I was leader for just one day, I'd build a city free of hate. I tell the people, drop the cross on your back and use the wood to build a new estate. Free food, free beer, free flowing open kitchens, equal rations to eliminate haste. Colored money won't count itself, so you can't change the numbers in a long gone paper trace. Though I may not have much time to make a change, don't have the army or the money, but I've got a cause. How long would it take? Ooh, would you make me leader for just one day? Ooh, you do. Would you make me leader for just one day? Taxi drivers would be perfect gents and take exactly where you like to go. Not that walking's not an option, cause the grasses would be greener and those shoes all good to go. I put the glasses in a garden instead of stuffy rooms. I throw the textbooks out the window. Still debating if there'd be any internet, cause if there was, it shouldn't be damn slow. Though I may not have much time to make a change, better for just one day. Low-headed taxes and safe bus companies, no withheld information from the schools to the youth to the shows on TV. I'm talking better weather warnings and safe evacuation. Fair price electricity, there should be no rewriting history. Zoning for infrastructure, no, 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 no. For every mall, 10,000 trees. Everyone well informed on reproduction, so I give respect to all religions. This is my call for a revolution. This is my call for a resolution. This is my call for a revolution. This is my call for a resolution. This is my
All right, welcome back to PBA Talks, a webinar on mass media and the law. Let's now proceed to our open forum. We have gathered questions from the comment sections here in our webinar and our social media accounts. We have a lot, but before we go to those, may I throw the first question to Secretary Salvador Panelo and of course to Dean Mel, obviously as a non-lawyer and not a professor of law. I just wanted to be very clear on this. Is there anything in the cybercrime law, is it clear rather in the cybercrime law that the prescription period is 12 years? Secretary Panelo, please go ahead.
There is a Supreme Court decision that says it's 12 years, or rather 15 years. The case of Tolentino, that's a decided case, not 12.
So it's even longer than 12 years now. Dean Mel, what do you say to that?
Well, there is nothing in the cybercrime law which provides for a prescriptive period. And even the Tolentino case is not a decision, it is a mere resolution. And a resolution does not form part of the law of the land. Only decisions of the Supreme Court become part of the law of the land. So now what the DOJ and the judge did in its original decision was to go into a pre-war, pre-Commonwealth period 1924 law, which provides that in case there is no prescriptive period, 12 years will apply. So yun ang ginamit ng DOJ at saka ng dating desisyon ng korte, ng lower court. Kaya lang, sabi ni dating Solicitor General Hardelesa na naging Supreme Court Justice, at sabi rin sa Revised Penal Code na pinasa noong 1930, malinaw naman by clear provision of the law that libel as a crime, libel as a crime as duly worded prescribes in one year. So therefore, ang talagang totoo dyan para lang sa akin, ang pananaw ko, talagang 1 taon lang. Sapagkat yan ay express provision of the law. Hindi ka na hindi ka na interpolate, interpret, etc. because when the law is clear, it must provide, must be applied. So yung sinasabing Tolentino, it's just a mere resolution. It's not even a decision. It's not even en banc or a provision of the law. Yun lang masasabi ko dun sa Tolentino yun. And as a matter of fact, even if you apply the Tolentino case, it was a resolution decided in 2018 when the material dates or years in the Ressa case is 2012, 2014, and 2017. And according to the Habinal case, you cannot apply decisions of the Supreme Court retroactively. Dapat prospective yan. Kaya therefore, ang judge mula sa 1, ginawa ng judge na 12, ngayon 15 na. Medyo lumaki na. So, palaki tayo ng palaki. Pero nakakita sa Court of Appeals, I think.
Opo. But is this, are you talking about this RA number 3326 that talks about special laws, such as the cybercrime law, that basically states if the offense is punishable by jail time of 6 years or more, like cyber libel, the prescription period becomes 12 years. I think this was the one used by the Justice Department.
Okay, ganito yan, Pinky. Ano bang year pinasa yung 3326, yung sinabi mong batas? 1924. Hindi pa pinapanganak siguro yung mga parents natin dyan. 1924 law, it is an act. It is a pre-Commonwealth law. Okay? Doon sinasabi na kung walang prescriptive period, 12 years. Ngayon dumating yung Revised Penal Code in 1932. Sinabi na doon, 1 year. Tapos dumating yung cybercrime law in 2012.
2012.
September. So
2012.
wala. So ano nga yung i-apply mo? Okay? Nung kinwestiyon namin yung cybercrime law in 2012, na ang kalaban namin si Solicitor General Hardelesa pa noon, sinabi niya sa amin noon na ang cyber libel was only 1 year. Cyber libel. At sinabi nga ng Korte Suprema in Dicini versus Court of Appeals that the cyber libel law did not create a new law on libel. It was still the original law on libel in the Revised Penal Code. So kung iyon ang susundan natin yung desisyon ng Supreme Court na yun na en banc, 1 taon lang. 1 taon lang. At hindi mo matitinag iyon sa isang mere resolution ng Supreme Court.
Okay. Very brief reaction from Secretary Panelo, please.
Well, for one, the RTC already made a ruling on that. On the basis of that, I think they filed an appeal. So we'll have to wait for the resolution of the higher court. But as far as this representation is concerned, according to this presiding judge, there was a republication. And that is why she applied the 12-year prescriptive period. Now, with respect to the claim that the 15-year period is not valid, that is a petition for certiorari filed before the Supreme Court. And a resolution was issued to that precisely. And saying that it's 15 years because of the penalty involved.
You know, there's really as many interpretations as there are lawyers. All right, let's go to the question from our open forum for Secretary Panelo from an attendee. Secretary Panelo, you mentioned that the closure of ABS-CBN is based solely on its expiration of congressional franchise and is the sole prerogative of Congress. The president does not meddle or interfere in that decision. Can you explain why the president has said publicly that the ABS-CBN franchise can never be renewed while he remains president, and that he also said that its closure results in the eradication of an oligarchy without the need to declare martial law? Aren't they inconsistent with what you said in your discussion?
No, because you know why? The utterances of the president, as I said in my speech, was expressions of displeasure. You must remember that the president, when he was a candidate for president, paid an ad, and that was not
aired
by ABS-CBN. In other words, he was expressing his anger. Are we going to deprive him of that? Expressing his own displeasure. But when the ABS-CBN chairman, president, apologized to him publicly, there was a closure because he accepted the apology. Now, with respect to the intrusion or interference of the president, free Congress, let us recall that the president appointed several members of the cabinet and whose appointments had to pass through the Commission of Appointments. If it is true that he interferes or he can influence Congress, then all the members of the cabinet appointed by him could have been approved. But some of them, I think 4 of them, were disapproved by the Commission of Appointments, and we never heard any opposition or any displeasure on the part of the president. Now, when he mentioned that he dismantled the oligarchy, he was referring to those who control, as he said, the resources, the natural resources like water and the electricity. He was not actually referring to ABS-CBN. You must remember that indeed it's only Congress that can either grant or renew a franchise. Nobody else can.
All right. And of course, as they say, that's a privilege. There is a follow-up question. Maria Ressa and ABS-CBN have both been mentioned and attacked by the president himself in many speeches. What impact? Sorry, that was a question I asked earlier. This is the next question. This is for Secretary Panelo again. As CPLC, would you advise for or against the regular publication of the president's health condition insofar as it relates to the people's right to information and the media's right to report on matters of public concern? Kindly explain.
First, the Constitution requires the revealing of such information only when he is in serious health condition. Secondly, we don't even have to ask him because he tells us every time what he is suffering from. He's very transparent.
But I guess the question would be more so a medical bulletin possibly, or?
That is not, Pinky, that is not required by the Constitution. And as I said, you don't even have to put that in medical bulletins because this president is so transparent. He tells you what he feels, what he's suffering from. He tells us from the very beginning.
So you don't advise, obviously, for the regular publication of the president's health?
It's not required, and it is not necessary.
For Dean Mel, are you saying that ABS-CBN and Maria Ressa had no legal faults or even deficiencies?
Okay. When you talk about Maria Ressa and we talk about the conviction in the last conviction, okay. When you talk about prescription, it is not merely technical. The Supreme Court said it is a substantial right. So one of the ways by which a crime is extinguished according to revised penal code is through prescription. Basta lumampas ang taning, napuputol na ang pagkasala, hindi na pwedeng kasuhan. So if we will be very technical on that, in that sense, wala ng crime. Okay? Pero, kung ang tinatanong mo sa akin, ang isang tao ay perfect ba? Hindi nagkakaroon ng mga faux pas o kaya mga pag-misstep? Hindi naman. Baka meron nga. Pero dapat we have to be sure that it is a crime. Because kung nagpaparatang ka at sinasabi mong may crime, dapat ma-prove beyond reasonable doubt at saka dapat nasa loob ng prescriptive period sapagkat our Constitution guides us all that a person is presumed innocent until proven guilty. Ngayon naman, punta tayo sa ABS-CBN. Okay. I-focus na lang muna natin sa ano ba ang mga rason ng Kongreso, bakit hindi pumayag dun sa franchise. Una, sabi nila, yung isang tao daw may-ari,
hindi Pilipino.
Dual citizen. Pero as we all know, we have already a law allowing dual citizenship. That in accordance with Section 5 of that law, a dual citizenship shall have the full political and civil rights as an ordinary Filipino. No second-class citizen. Second, sabi ng Kongreso, nung committee yon na nag-tax avoidance daw yung ABS-CBN. Tanong natin sa 1,000 pang mga abogado, ang tax avoidance, hindi tax evasion. Yun ay permissible. Pangatlo, sabi, it is possible daw that there may be foreign ownership. But that's the realm of the possibility. Possible yes, possible no. Sa korte, hindi ubra ang mga posible lang para makausad sa kaso. And then the dummy thing, apparent dummy. Ang ibig sabihin ng apparent, this is not my wording. Wording to ng Kongreso. Sabi, there can be apparent violation. Alam niyo ba apparent? Kung tumitingin kayo sa labas, nakikita niyo ang araw, umaakyat, bumababa, pero hindi yun ang tunay na nangyayari. Pero obvious yun. Ang alam natin na nangyayari, ang totoo, umiikot ang mundo. Yun ang apparent. So, bakit? So, ibig sabihin, maring oo, maring hindi. Hindi nakikita ang totoo. Kaya, yung mga grounds na yon, hindi pwedeng pumasa yun. Tapos, ang sinabi nila, sabi nila doon sa mga laborers, na hindi daw exemplary ang ginawa ng ABS-CBN sa pagtrato sa kanilang mga laborers. Pero anong ginawa? Tinanggal yung 11,000. That for me, I question the humanity of that one. Sinasabi niyo mali ang trato niyo sa laborer, tapos tinanggal niyo sa trabaho, 11,000. And that is, ito yung sinasabi ko. Even if it were a privilege only a franchise, the power is granted by the Constitution, and therefore the granting and the rejection of the franchise must be guided by the precepts of the Constitution. Kaya dahil sinasabi ng Constitution natin, protect labor, protect industry, enhance communication, freedom of information. Iyon ang mga konsepto sa Constitution na napakataas na dapat sinaalang-alang ng Kongreso. Pero anong sinang-alang-alang nila? Avoidance, permissible naman. Possible yes or no. Apparent, not really the truth. Maaring yes, maaring no. And also, double citizenship. We have a double citizenship law. So the grounds are flimsy, di ba? And it's not a question of giving arbitrary preference. It is a question of looking the historical value of an entity which has enhanced democratic values like freedom of expression and information. Yun ang mga matataas na values na dapat nasa alang-alang. Hindi yung alam mo ba yung panatang makabayan. Hindi yun eh. Hindi yun ang pinag-uusapan eh. Kaya that's my point.
Very brief, maybe a reaction from Secretary Panelo on what Dean Mel is saying, flimsy grounds.
Alam po ninyo, yung sinasabing flimsy grounds, ang magdi-decide na ng Kongreso. They've been mandated by the Constitution to grant or deny. If you do not pass the standards imposed by Congress, that has the exclusive and sole authority to either give you,
Grant or deny.
talagang yun eh. Yun na yun. Para sa kanila, mayroong violation. Sinasabi nila na, bakit meron? Sabi ng mga ahensya ng gobyerno, wala namang violation with respect doon sa DOL, doon sa BIR. Nandun ako kung wala nga. Pero there are other violations eh. And it doesn't mean that porque you complied with certain laws and you violate other laws, matatakpan na yung violation mo. Yun ang kinonsider ng Congress.
Why was it, siguro Secretary Panela, not considered that if there were indeed alleged violations or infractions, to actually refer them to the concerned agencies and let them correct any error or violations?
Sila nga magdi-decide, Pinky. Walang iba. Sila yon. Iba yung... Kasi meron na nga mga desisyon yung mga appropriate agencies na hindi nag-violate on certain circumstances. Pero sinasabi ng Kongreso, dito nag-violate ka. Okay, as far as we're concerned, you violated. Hindi ka karapat-dapat na bigyan ng franchise.
Okay. I just do a follow-up on both gentlemen. Do you think that it is right for Congress to be the one to be either granting or denying franchises? Because some say this could be politicized. Dean Mel, I'll start with you.
Well, the power of Congress to grant a franchise has always been there. Has always been there. But you have a very good point. Perhaps it is about time to look into it again. But politicizing deals with the person talaga. So the only thing we can do is just wait for 2022 and perhaps elect new people to be more discerning and to be more constitutional.
See, Secretary...
We can do. But that's the only thing we can do as of now.
Secretary Panela, what about you? Would it be wise to have another agency probably grant or deny the franchise instead of the House of Representatives, because it is initiated at the House of Representatives before it goes to the Senate?
The question should be answered by, if we have a new constitutional convention or an amendment to the Constitution, the framers, who they will divest Congress of the exclusive authority. Meanwhile, yun ang sinasabi ng saligang batas.
No, but my question is, would you favor that? Would you favor a possible transfer of this privilege granted, denying or granting franchises to another body?
No.
No. Okay. Next is a question from Ellen Tordesillas. Could the speakers and reactors comment on what Senator Bongo and the NBI are doing? Go does not file libel suits against those who criticize him in social media, yet NBI summons these people. Bongo announces that the summons without telling the public that there were those posts. Aren't those intimidation? Maybe I'll ask Attorney Cruz first to respond to that.
I referred to that in my brief reaction. The fact that the good senator causes the investigations done by the NBI regarding the alleged fake news reports sharing, which refer to him, no? Well, that particular act produces what is referred to in jurisprudence as a chilling effect. The basic purpose of such move would be to silence the citizenry, stop them from criticizing him. Now, I think that is a very eloquent and clear indication that indeed there are men in this administration who weaponize. That's my statement.
Okay. Maybe a brief reaction also from Dean Mawis, if you will.
I totally agree with Professor Cruz. It has a chilling effect, especially with when you think of what he's saying is not consistent with what is happening, people will tend to be scared, if they know that their words will merit sanction. I totally agree with Professor Cruz.
Thank you, Dean. What about Attorney Domingo? Also a quick reaction, please.
I would address that to the senator, because he has the prerogative to, or even the right to file the necessary libel suit or whatever. But in any event, I think there's jurisprudence to the effect that he should not be onion skinned. He's a public figure, he's a public official, and he should be very sensitive to what the constituents would be sensitive about. So I think it was ill-advised, and I do not advise that for Senator Go, for his sake.
All right, next question. Can we reconcile the fact that a broadcast company needs to secure a franchise before it may operate with the demands of Section 4, Article 3 of the Constitution, which states that no law shall be passed abridging the freedom of speech, of expression, or the press, or the right of the people to peacefully assemble and petition the government for redress of grievances? I'll ask Secretary Panelo first.
I didn't get the question again. Can you?
To reconcile, Secretary Panelo, the fact that a broadcast company needs to secure a franchise when in the demands of Section 4, Article 3 of the Constitution states that no law shall be passed abridging the freedom of speech, of expression, or the press.
But there's no connection between the grant or denial of a franchise. Why should you connect the freedom of speech? They're saying that when you deny the franchise of ABS-CBN, you curtail the freedom of speech of the press. Why? It doesn't mean that when you deny one network of a franchise, you already destroy the right to freedom of express yourself or of the press. In fact, the fact alone that the franchise ascended with respect to ABS-CBN, we still have all the practitioners of media doing their work.
All right, next is from another question. I'd be interested to hear how Dean Santa Maria would prefer to redefine suspicion, if he thinks it's defined over broadly, vaguely, or not at all. Hopefully a definition that still allows the authorities to do their jobs.
Okay, let me explain this thing. There is only one thing clear in the Anti-Terrorism Act, and that is suspicion. Iba malabo, but there is one very clear usage of a word, suspicion. Masyadong malinaw yon. Doon hindi tayo nagtatalo. Para sa akin, malinaw na malinaw yon. Sabi ng Section 29, ito sabi ng Section 29, on the basis of a mere written authority from the Anti-Terrorism, any military personnel or police can take into custody a person, and now I'm quoting now, verbatim, a person suspected of committing the crime, Section 4, 5, 6, 7, 8, 9, 10, 11, 12 of the Anti-Terrorism Act. Yung word na suspected of committing a crime, malinaw yon. Yung Section 4, 5, 6, 7, 8, 9, 10, 11, 12, malabo yon. So pinagsama mo ang malinaw na base ng panghuhuli sa malabong mga offense, talagang gagalaw ang imagination ng nanguhuli. Ngayon, ito yung sinasabi ko kanina. Is that within the spirit of the law to literally apply the meaning of suspicion? Yes, that was their intention. Why did I say that was their intention? Because the phrase suspected of committing a crime has been repeated not once, not twice, not thrice, but 8 times in the law. That is in your sections 3 3C, 16C, 29 twice, 30, 32, 46, and 48. Kung sunod-sunod na ginamit yung phrase na yon, alam natin hindi aksidente yon, sinadya yon. Tapos, sa batas na to, you will see that dalawa ang sitwasyon na parating involved. Isa, charged with, isa, suspected. You can see that in section 16, 30, and 46F. Charged with or suspected. Yung charged with, at least siguro may probable cause yun. Pero yung suspected, mas mababa na sa probable cause yun. Suspected, suspect lang. Ngayon, we know in statutory construction that if a word has to have a different meaning, the law itself must define that different meaning. Sa anti-terrorism law, section 3 provides the provision which says definition of terms. Nowhere in that definition of terms is the word suspected defined in another way. So that therefore, suspected must mean literally what you and me knows, the ordinary interpretation of ordinary citizen. Hindi mo pwedeng gawin to. Ang nababasa mo aso, ang ibig sabihin pala pusa. Hindi ganun yan. Kung anong nakikita mo, yun ang gagawin. Kaya suspected, malinaw, crimes, malabo. Sino magdedetermina nun? Ang ATC, Anti-Terrorism Council, sa tulong ng mga pulis. So, kung malabo ang offense, iikot ang imagination, sila ang magde-decide. Kaya overbroad at saka vague. Yan yun. Yan ang sagot ko.
Secretary Panelo, please respond because it seems like that suspicion could actually be very subjective. Parang ganun nga, sabi ni Dean Mel, pwedeng umikot ang ulo and siguro ikaw mag-isip kung anong palagay mo, kung ano yung kaso o kasalanan ng tao. Parang ganun po yun. Secretary Panelo, please go ahead.
First, section 29 does not refer to ATC giving authority for a particular military or police officer to arrest. They've been misreading this section 29. They're always saying that they're using the phrase having been duly authorized in writing by the ATC. Alam po ninyo yung having been duly authorized. That refers to sections 16 and 17. Because under those sections, if a police officer or military person suspects someone to be involved in terrorism, what they will do is to ask permission from the ATC to file an action in the Court of Appeals to seek permission to surveil the suspected terrorist because they need evidence. All right. When they're granted by the Court of Appeals the permission to surveil, then necessarily they will be doing that. And they will be getting the evidence they want. Okay? Kung baga, merong probable cause na silang nakuha, and that is why Section 5 of Rule 113 will apply. They will decide to arrest. Okay? So yung Section 29 refers to that. This Section 29 already assumed that the military officer and the police officer has arrested a suspected terrorist on the basis of the existence of probable cause pursuant to Section 5 of Rule 113. Kaya nila nakuha yun because there was already an authority coming from the Court of Appeals. Itong Section 29 refers only kung na-arresto na dahil nga merong probable cause under warrantless arrest. Pinag-uusapan na ngayon dito kung hahabaan mo yung pagtitini mo dun sa tao.
In fact, I think also, Secretary Panelo, this is something underscored by Senator Ping Lacson kasi nagkakaroon daw ng supposed to be confusion between designation and prescription. I wrote it down. He said that designation is an administrative act that can be exercised by the executive branch through the ATC. However, prescription is, I guess what you're saying is judicial, which only the courts, the Court of Appeals under the Anti-Terrorism Act of 2020 can decide with the burden of proof coming from the DOJ. However, we have come to the end of this discussion. We need to say goodbye and say thank you to all those who have attended. And I'd like to thank, of course, the PBA for having me as a moderator. I learned so much. I wish we had more time. Very enlightening and informative for me as well.
Can I say something about Senator Bongo?
Sure.
Very quickly lang. You know,
Sige,
we have
sir.
a cybercrime law. We're supposed to enforce that law. Kaya nga si VP Lenny nag-file din ng libel case eh. Kasi ang feeling niya, binabiolate yung kanyang rights. Ito naman si Senator Bongo, ganun din ang feeling niya. Kaya pinapa-imbestiga niya. I don't think there's anything wrong with that. With respect dun sa sinasabing there's a chilling effect, my goodness, chilling effect. Eh mas matindi nga rin ang mga kritisismo and wala namang pinapile ng kahit na sino against anyone coming from the president, di ba? Wala.
All right. Is that it, Secretary Panelo?
Yes.
Okay. Secretary Panelo, thank you so much. And of course, to Dean Mel, maraming salamat. And to our reactors as well, Dean Mawis, Attorney Cruz, and Attorney Rico Domingo. So there will be a token that will be given to all of you. And at this point, I'm asked to ask all of you to turn on your video for a picture taking, a photo op. So if we can do that for a bit. And thank you very much for attending the first PBA Talks, Mass Media and the Law. We have also rather closing remarks. Let's listen to Harvard Law School Association of the Philippines President, Attorney Alfredo Molo III, and Philippine Bar Association President, Attorney Jose Perpetuo Lotilla.
Good afternoon, everyone. It was a pleasure for us in the Harvard Law School Alumni Association to partner with the PBA in conducting these series of talks. We know that everyone is drowning in hundreds of webinars lately. That is why our goal in this project is to offer topics that are lively and of great interest to PBA members and the general public. We also want to be that venue where both sides of any issue are, to the extent possible, equally represented. It is said that the true test of one's ideas is their acceptance by the market. It is our hope to be part of that market. It is our hope that by presenting champions from both sides to make their arguments in front of you, we can come to an agreement as to what the fundamentals of the Constitution and the rule of law are today, and more importantly, what they should be. We hope today's talk was a good start, and we intend to provide equally engaging topics and speakers in the future. Before I end, I would like to make two announcements. First, that the Harvard Law School Alumni Association of the Philippines has an incoming president, and that is Professor J.J. Isini, who needs no further introduction. He is, after all, a known tech practitioner and an industry leader. And second, if you have a topic in mind that you think would make a great theme for a future PBA talk, let us know. Or perhaps there's someone you want to hear from. Tell us. Part of our goal is to make these talks interactive. We want to listen to what the market wants. And that market is you. Thank you, everyone, and have a good afternoon.
First of all, I wish to thank all of the participants in this first ever webinar of the Philippine Bar Association. Without your participation, this would not have been as successful as it has been today. Furthermore, I wish to thank all of the speakers who have devoted their time and effort for today's webinar. I refer to Attorney Carlo L. Cruz, Professor of the College of Law, Lyceum, University of the Philippines. Attorney Rico V. Domingo, our very own first Vice President of the Philippine Bar Association. Dean Melancio S. Santa Maria, Dean of the Far Eastern University College of Law. The Honorable Salvador S. Panelo, Chief Presidential Legal Counsel. Dean Maria Soledad Margarita de Requito Mauis, Dean of the College of Law of the Lyceum University of the Philippines. And of course, our host today is Joanna Marie, broadcast journalist. Furthermore, I wish to thank our past president, Pope Salis, and past president, Fina de la Cuesta, and our Philippine Bar Association treasurer, Ernestine Villarreal Fernando, for their participation today. And without their efforts, together with their staff, this event would not have happened. Thank you very much. Good afternoon.
Again, thank you so much for attending the first PBA Talks Mass Media and the Law. We'd like to thank our speakers and our reactors as well. I'm still trying to find out if we're going to have the adjournment from PBA President Attorney Lotilia.
I hereby close this session.
Bye.
Thank you. Bye-bye.
Bye, Attorney Sal. Bye, Dean Mel.
Bye.
Bye-bye.
Thank you, Attorney Cruz.